Okay, let's dive into something really fundamental, family, and specifically how different legal systems, like Islamic law, handle the really complex issues around children.
That's right. Today we're taking a deep dive into children in Islamic family law, things like legitimacy, custody, guardianship.
And we should mention up front, the source material we're exploring comes from resources generously made available to students by the University of London.
Yes, and we're using this purely for educational purposes. Our goal here is really to help you unpack the core ideas, especially, the variations and how modern laws play a role.
Absolutely. So our mission, if you like, is to break down these concepts, traditional rules, differences between schools, modern changes, hopefully making it clear, especially if you're prepping for an exam on this.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
A big thank you to Sinorbit Academy. And yes, to echo that, if you are facing exams on this topic, really good luck. We hope this helps.
So the plan is pretty straightforward. We'll start with how legitimacy is figured out, then get into the big topic of child custody hadina, and finish up with guardianship of property.
Sounds like a good path. Let's jump in. Where do we start with guardianship?
Okay, so guardianship is absolutely central in Islamic family law concerning kids.
Right, and I know traditionally the father often had, well, the primary role, but we're seeing shifts with modern laws, aren't we?
Definitely. And it's crucial right from the start to get your head around the fact that traditional Islamic law sees three different kinds of guardianship for minors.
Three types. Okay, what are they?
First, there's custodial care. That's adana. It's the day-to-day, hands-on physical care.
Yeah.
Feeding, clothing, where the child actually lives.
Okay, the everyday stuff. Practical care.
Exactly. Second, you have guardianship of the person. This is broader. It's about making the major life decisions, education, travel, traditionally even arranging marriage.
Right, and the third.
Guardianship of property. So if the child has assets, inheritance, whatever, this is about managing that until they're old enough.
Okay, Hadena for physical care, guardianship of the person for big decisions, and guardianship of property for finances. That distinction, especially between care and the sort of overall decision-making power, seems really fundamental.
It really is. You absolutely need to keep those separate in your mind to understand who's responsible for what, both traditionally and how things might work now.
All right, let's tackle that first step then. Legitimacy. How does Islamic law actually determine if a child is legitimate? Where's the starting point?
The starting point is a foundational legal principle, a phrase you hear a lot. The child belongs to the marriage bed.
The child belongs to the marriage bed. Sounds quite evocative. What does it mean legally?
It means there's a strong presumption. If a child is born during a valid marriage, or importantly, within a specific time frame after that marriage ends through death or divorce, the child is legally presumed to be the husband's.
So the marriage itself creates this link.
Yeah.
And the timing is key, you're saying.
Hugely important. Now, everyone agrees on the minimum. If the child is born 6 months or more after the marriage contract, the presumption applies. That's seen as the minimum possible gestation.
Okay, 6 months minimum.
Where it gets really complex and where you see major differences between the schools of thought is the maximum period of gestation they recognize after the marriage is over.
Ah, and this is where those, well, frankly, surprising time frames come in.
Exactly. The four main Sunni schools differ quite a bit. The Hanafi school, for instance, allows up to 2 years.
2 years after the marriage ends. Still presumed legitimate.
Yes. And it gets longer. The Shafi'i and Hanbali schools traditionally go up to 4 years.
4 years.
And the Maliki school traditionally allowed up to 5 years.
5 years. I mean, from a modern medical view, that seems impossible. How did they justify that?
It does seem impossible now, yes. And the classical jurists, they knew about normal pregnancy lengths. To explain these very long periods, particularly in the Maliki, Shafi'i, and Hanbali traditions, they came up with the concept of the sleeping fetus.
The sleeping fetus. You mean it just sort of paused development?
That was the legal idea, yes. A kind of legal fiction suggesting the fetus could remain dormant or its development wasn't continuous, allowing a birth years later to still be linked back to the marriage. It was a way to make the legal outcome fit.
Okay. And how does that compare to the Shia view?
The Shia perspective is much closer to biological reality. They generally recognize a maximum gestation period of around 10 lunar months.
Right, much more aligned with what we know medically. So if a birth falls within these periods, however long the school says paternity is presumed for the husband, unless
the husband formally challenges it using a specific procedure called lean-in.
Lean-in. What's that involve?
It's quite serious. It involves mutual oaths before a judge. The husband swears repeatedly he's telling the truth about accusing his wife of zina, unlawful intercourse, and that the child isn't his, invoking God's curse if he's lying. The wife then swears repeatedly the husband is lying, invoking God's wrath on herself if she's lying.
Wow, very solemn. And if that happens,
If Lanny is completed, paternity is formally denied, the child is considered illegitimate in relation to that man, and it also dissolves the marriage.
you mentioned the Ida period earlier, that waiting time for women after divorce or widowhood. How did these long gestation rules affect Ida?
Ah, good point. Traditionally, if a woman claimed pregnancy after her marriage ended, her Ida lasted until she gave birth, so with schools allowing 2, 4, even 5 years for gestation.
She could claim maintenance for all that time.
Potentially, yes. By claiming she was still pregnant and thus still in Ida, it created practical issues and potential for, well, drawn-out obligations based on medically unlikely claims.
So modern laws had to step in.
Exactly. Many Muslim countries brought in legislation to limit this maximum recognized gestation period, often bringing it down to around 10 lunar months, aligning with medical facts. This capped the Ida based on pregnancy. These laws also often allowed non-access proof the couple couldn't have been together as a way to challenge paternity. Egypt's Law 9025 of 1929 was an early important example of this kind of reform.
But wasn't there a counterexample? A place that went back to the longer period?
Yes, for a while, Pakistan actually amended its law to revert to the traditional Hanafi 2-year rule for legitimacy after dissolution, which shows that traditional interpretations can still hold significant sway.
What about cases where, say, a couple married by proxy and never actually met? Does the presumption still apply then?
Another difference between schools. Hanafi law traditionally said yes, legitimacy is presumed 6 months after the contract, regardless of access, but other Sunni schools and the Shia generally require at least the possibility of access or consummation for the presumption to hold. And again, modern laws like Egypt's often explicitly require proof of access.
It makes you wonder, why develop such seemingly counterintuitive rules like the 5-year gestation or the sleeping fetus in the first place? What was the goal?
That's a really important question. The main driver seems to have been social and, you could say, humanitarian. The rules were designed primarily to avoid declaring children illegitimate.
It's because the consequences were so severe.
Extremely severe. Traditionally, an illegitimate child had basically no legal connection to their biological father or the father's family.
Meaning what exactly for the child?
It meant no right to inheritance from the father, no right to maintenance from him. Legally, the child was linked only to the mother. So these broad presumptions and long timelines acted as a shield, trying to ensure as many children as possible had a legal father and the rights that came with that.
And you also said it protected the mother.
Yes, significantly. If the child was deemed legitimate, it greatly reduced the chance of the mother being accused of zina, which carried very harsh penalties historically. So it protected the child's status and the mother's reputation, even her life.
Okay, so traditionally, the status of an illegitimate child regarding the father was, well, non-existent legally, both Sunni and Shia.
Correct. Traditionally, no legal relationship.
Have there been any changes or exceptions to that strict view more recently?
There has been some movement, yes. Particularly notable is a development in Iran. While traditional views persist, a significant opinion attributed to Ayatollah Khomeini argued that a biological father does have duties, like maintenance, towards his illegitimate child. But, and it's a big but, there are still no mutual inheritance rights.
That's quite a shift, acknowledging a duty even without the full legal link. What about acknowledgement? Can a father just acknowledge a child?
Yes, acknowledgement is another way paternity can be established. A man can acknowledge a child as his, but it's generally only valid if the child's paternity isn't already established elsewhere. They couldn't possibly be the child of someone else, like another woman's husband, and the age difference is biologically plausible.
Got it. And lastly, on status adoption. Is formal adoption, creating full legal parent-child ties, a part of traditional Islamic law?
Traditionally, no. Formal adoption, in the sense of completely substituting biological lineage and creating inheritance rights from the adoptive parents, isn't recognized. Pre-Islamic practices were modified. However, caring for orphans or foundlings, kafala, is highly encouraged, a major act of charity. It's about providing care and upbringing, but without legally changing the child's original family name or inheritance rights, if known.
But like with legitimacy, modern laws have sometimes changed this.
Absolutely. Tunisia is the key example here. Their law of 1959 specifically allows for full legal adoption. It can apply to abandoned children or even children with known parents if they consent. Adopted children in Tunisia get the same rights as biological children, including inheritance and the adoptive family's name. It's a very clear legislative departure from traditional doctrine.
Okay, legitimacy is clearly complex, tied to marriage, varying gestation periods, modern reforms. Let's move on. After a marriage ends, or just generally the care of children is paramount, let's talk custody or hadana. What's that core division of roles we touched on?
Right. The foundational principle agreed across the schools is that primary guardianship of the role of the wali, the ultimate decision maker, belongs to the father. If he's not there, it typically goes to the paternal grandfather, then other male relatives on the father's side. The mother is traditionally never the guardian of the person.
Her right is specifically hadana.
Yes, her right is hadana, the right to have custodial care of the child, usually for a specific period.
So let's stress that again. Father is the wali, guardian of the person, big decisions. Mother has hadana, custodial care, day-to-day life. That difference is crucial.
Absolutely crucial. The father, as wali, decides education, long-term residence, travel, potentially marriage. The mother, with hadana, is responsible for the child living with her, the nurturing, the immediate physical well-being.
Okay, what if the mother is no longer able to have hadana? Maybe she passes away or remarries inappropriately or something else happens. Who gets the right of care then?
And here again, the schools differ on the order of priority. The Hanafi and Maliki schools generally prioritize the female line after the mother. So hadana would typically pass to the maternal grandmother, then great-grandmother, and so on.
So it stays with the mother's female relatives.
Often, yes, in those schools. But the Shafi'i and Hanbali schools and the Shia don't give the female line that same priority. In Shafi'i and Hanbali law, after the mother loses the right, it tends to go straight to the father, then his line. In Shia law, it goes directly from the mother to the father, then the paternal grandfather.
So even the sequence of who's next in line for care varies. What makes someone qualified to be a custodian, a hadina? Are there basic requirements?
Yes, all schools agree on the essentials for the child's welfare. The custodian must be an adult, mentally sound, trustworthy, physically capable of providing care, and live a moral life. It's generally looked at case by case, focusing on the child's best interest.
Are there specific things that would disqualify someone, especially a mother?
A major one, agreed by all schools, relates to marriage. A woman generally loses her right to hadana if she marries a man who is not related to the child within the prohibited degrees.
Prohibited degrees,
Yeah.
meaning men the child couldn't marry, like an uncle or grandfather?
Exactly. If she marries someone outside that close family circle, the law traditionally assumes the new husband might not prioritize the child's interests, or it could disrupt the child's ties to their paternal family. So she loses the right to keep the child physically with her in that new household.
That makes sense, a kind of protection mechanism. Any other common reason she might lose hadana?
Another key one is if she tries to move the child too far away, effectively removing them from the father's sphere of influence. If the father, as wali, can't reasonably visit and oversee the child's upbringing because of the distance, she could lose custody.
Okay. What about religion? If the mother isn't Muslim, can she still have custody of her Muslim child?
Another area of disagreement. Hanafi and Maliki schools generally say yes, she can, as long as she doesn't actively try to convert the child or raise them in her faith against Islamic principles. But the Shafi'i and Hanbali schools traditionally say, no, a non-Muslim woman cannot have custody of a Muslim child, period, even if she's the mother.
Wow, that's a stark difference, highlighting different priorities, maternal bond versus religious identity. Now, maybe the most variable part, the duration of the mother's hadana. How long does she keep the child before custody might transfer, typically back to the father? This seems like a key thing to remember for exams.
Absolutely. The ages are very distinct and important to know. Let's go through them again. Hanafi. Mother keeps a boy until 7, a girl until 9.
Okay, 7 and 9.
Maliki.
Yeah.
Much longer. A boy until puberty, a girl until she marries and consummates the marriage.
Right up to adulthood, essentially.
Shafi. Both boys and girls get to choose which parent to live with around the age of reason, typically 7.
Choice is 7.
Hanbali. Similar, but only boys choose at the age of reason, around 7. Girls usually stay with the mother longer, unless she's disqualified.
Okay, only boys choose in Hanbali.
And Ithna Ashari Shia, the mother's right ends quite early, sons at 2, daughters at 7.
2 for boys. It's very early. So these ages are all over the map. Have modern laws tended to stick with these, or have they generally extended the mother's period?
They've almost universally extended the mother's period, especially moving away from those very early cutoffs like the Shia age for boys or the Hanafi ages. For instance, Morocco's 2004 family code clearly prioritizes the mother, then the father, then the maternal grandmother for custody. And crucially, it says the court must consider the child's view if they're over 15.
Bringing the child's voice in.
Exactly. And in Iran, where Ithna Shari law applies, the civil code was amended so the mother now keeps both boys and girls until they are 7, a significant extension for sons compared to the traditional rule.
So definitely a trend towards longer maternal custody and considering the child's well-being and sometimes their wishes.
Yes, reflecting a shift towards prioritizing the child's best interests in a more modern context.
Okay, that covers legitimacy in custody, Hadena. Let's quickly touch on the third type, guardianship of the child's property. Who manages a minor's assets?
The primary guardian of property is the father. He's the default manager of his children's finances. He can also appoint someone in his will, an executor, to manage the property after his death.
And this lasts until when?
Generally, until the child reaches the age of majority. This is traditionally considered attained by 15 years old at the latest, for both boys and girls. At that point, they usually gain the legal capacity to manage their own property and enter contracts.
What if someone reaches 15 but just isn't ready? Maybe they have issues or are easily taken advantage of.
In that situation, if the child is judged to be, say, mentally incapable or a spendthrift or just too naive upon reaching majority, the property guardian can apply to the court, the Qadi, to have the guardianship extended until they are deemed competent.
And the guardian has a serious duty here, like a trustee.
Precisely. It's a fiduciary relationship. The guardian must act in the child's best financial interests, taking care of their property responsibly, just as they would or should with their own. It's a position of trust.
Now, wasn't there a specific, quite different rule here in Maliki law, especially regarding girls?
Yes, that's a significant distinction in traditional Maliki law concerning females and property. While boys gain capacity around 15 like other schools, a female, under this traditional view, only gains full capacity to manage her own property after she contracts a valid marriage and it's consummated.
Only after marriage consummation.
Yes, and even then, there was a further restriction. A married Maliki woman traditionally couldn't give away more than 1/3 of her own property as a gift or charity without her husband's permission.
That's quite a major difference compared to other schools and modern standards of female property rights.
Yeah.
Really highlights the diversity within Islamic legal traditions.
It certainly does. It shows how different schools balanced various factors.
Okay, we have covered a lot of ground. We look at legitimacy, that core idea of the marriage bed, the sometimes surprising gestation periods varying by school, and how modern laws have often streamlined things like in Egypt or Tunisia.
Then we dove into custody, Hadana, really stressing that key difference between the father as wali, guardian of the person, and the mother's right to physical care, Hadana. We saw how the order of who gets custody next differs, the qualifications needed, and things that could make a mother lose that right, like remarrying certain people.
And we repeated those crucial differing ages for how long the mother's Hadana lasts, from just 2 years for a Shia son up to puberty or marriage in Maliki law. And we saw the modern trend, like in Morocco or Iran, extending these periods and sometimes considering the child's opinion.
And finally, guardianship of property. The father's primary role, majority usually at 15, the fiduciary duty involved, and that unique traditional Maliki restriction on female property capacity until marriage.
Understanding these details, especially the school differences and the impact of modern legislation, feels really crucial for anyone trying to get a proper handle on this area. It's definitely not monolithic.
And just to remind everyone, this discussion was for educational purposes, based on materials from the University of London.
And brought to you by Sinorbit Academy, Sri Lanka.
So maybe a final thought to leave you with. When you look at all this diversity in interpretation and these ongoing legal reforms trying to balance tradition with, child welfare concerns, how do you see these principles playing out and evolving in Muslim societies today? How is that balance being struck in practice?
That's a really interesting question to ponder. For all of you studying this, maybe for an exam, we really do wish you the best of luck. Go back over these points, compare the schools, look at the modern changes. It's fascinating stuff.
Absolutely. Keep learning.